Hi, welcome to today's edition of the analysis. Today we're discussing the breaking news that 11 governors of the People's Democratic Party have headed to the Supreme Court for Fubara. Governors of the PDP that have gone to court, the states are Adamawa, Enugu, Osun, Oyo, Bauchi, Akwa Ibom, Plateau, Delta, Taraba, Zamfara, and Bayelsa. We are yet to hear confirmation from this state of the federation because some of the things in Nigeria, sometimes you hear that all the states have gone, all the PDP states, and before you know it, one or two will come and say they have not authorized the filing of the suit. But we take it as it is that 11, take it as it is and take it as reported that 11 PDP governors have headed to the Supreme Court for Fubara. Recall that a few weeks ago, the President of the Federal Republic of Nigeria, working in conjunction with the National Assembly, suspended Governor Sim Fubara of Rivers State and also suspended his deputy, Professor Ngozi, and also suspended the House of Assembly. The governors of the PDP, because Fubara is also a governor of the PDP, they've gone to court straight to ask the Supreme Court for interpretation. And what exactly are they asking for from the Supreme Court? One, they are asking that the Supreme Court should determine if the president has the power to suspend the democratically elected structure of a state. President, whether he has the power to suspend a democratically elected structure. And that would include the governor, the deputy governor, and the State House of Assembly. Two, to determine if the way and manner the president pronounced the state of emergency in Rivers State is not in contravention of the 1999 Constitution. Three, whether by the Constitution the president can lawfully suspend or in any way interfere with the offices of governor and deputy governor of any states of the Federation of Nigeria and replace the governor with an unelected sole administrator. Unelected sole administrator under the guise of proclamation of a state of emergency. And the number 4 thing they want from the court is whether the suspension of a governor is not in contravention of the Constitution itself. So they've gone asking the Supreme Court to interpret this and give a clear roadmap as to what should be the position moving forward. Now, the question would be, why have the governors gone straight to the Supreme Court? Does it not amount to building a house from the rooftop? That's the question lots of persons may be asking. Why? Because we are used to parties going to the trial court, maybe the Federal High Court, and from the Federal High Court, they move to the Court of Appeal, and from the Court of Appeal, they now go to the Supreme Court. So why is this one different? Why are the governors going straight to the Supreme Court? Which is one of the major reasons why I'm making this video, to explain to the viewers how and the circumstances that, the governors will have to go straight to the Supreme Court instead of starting from the trial court. Maybe the governors are saying, if we start from the trial court, it's going to take a lot of time. And what we're challenging is to last for 6 months. So if we start from the trial court, it will certainly, be in court for more than the 6 months. So where do they now have the authority to go straight to the Supreme Court? Their authority is derived from the Constitution. What section? Section 232 sub 1 of the Constitution. What does it say? Quote, the Supreme Court shall, to the exclusion of any other court, have original jurisdiction in any disputes between the Federation and a state or between one state and another, if and insofar as the dispute involves any question, whether of law or of fact, on which the existence or extent of legal rights depend, right? So the governors have gone to the Supreme Court using this provision of the Constitution as their anchor. Now, how many days does the Attorney General of the Federation have to respond to this suit? The answer is 14 days. Who will appear in the court in the prosecution of this matter and in the defense of this matter? For the office of the Federal Attorney General that is going to defend this matter, the Federal Attorney General is expected to appear in person. That's the Chief Law Officer of the Federation. He's expected to appear in person to address the Supreme Court and justify the action of the president. That is his role. He has to justify the action of the president, supporting it with law. But note that the Federal Attorney General has the power to delegate this by handing it over to a legal practitioner, a private legal practitioner, senior advocate or non-senior advocate that he has confidence in, and then he has to give a fiat to that effect, authorization, and then the prosecution, the defense of the matter will be done for him by such legal practitioners that have been so authorized by him. The same applies to the to the State Attorney General. Attorney General of any of these states of the Federation that have gone to court, they have to appear in person. They are expected to appear in person. But where they are not disposed to appearing in person, they can engage the services of private legal practitioners to attend to the case for them. In most cases that go to court, you expect objection. I have been a practicing lawyer for many years. I've done 15 years. And I can tell you that most of the cases that we do in court, if you are on the other side, you will mostly raise objection to see how you can truncate the matter, without the matter necessarily being heard to the end. But if there is no objection, you allow it to roll to the end. So I foresee some objections in this matter. Number one, local standing. I see the Federal Attorney General challenging the local standing of the 11 governors of the PDP to bring this suit before the Supreme Court. I see the Federal Attorney General arguing that the most appropriate person to have brought this matter would have been Governor Fubara, who is the person that is directly affected by the proclamation of the president. So, Fubara and the deputy, Professor Ngozi, will be the most appropriate parties to have taken this matter to the courts. But if that is the case, Governor Fubara will not come straight to the Supreme Court. He has to start at the trial court. So I see the Federal Attorney General raising that issue. The second objection I can see is whether there is any dispute between the Federation of Nigeria and any states among the 11 states that have gone to court. We go back to this section of the Constitution, which says, the Supreme Court shall, to the exclusion of any other court, have original jurisdiction in any disputes between the Federation and a state. Underline, disputes between the Federation and a state, or dispute between one state and another. I see the Federal Attorney General asking the question as to whether truly there is any disputes between the federal government of Nigeria and any of these states that have gone to court. I hope that the persons that have taken the matter to court, they have prepared their minds for this, because I can foresee this as a practicing lawyer. Number three, the third objection is whether an issue affecting river states can be challenged by a good neighbor. The declaration of state of emergency has not affected any of these states. So can they now challenge the course of action that has arisen in river states? That's one of the objections that I have seen. But I know that the lawyers that will appear before the Supreme Court to argue these, either for or against, are prepared to face all the hurdles and address them one after the other. Finally, what do we want to see ordinary citizens like all of us that are not in power, that are not governors, that are not affected by the declaration of state of emergency. What do we want to see? We that are observing, right, as citizens of the country. What we want to see is expeditious hearing of this matter by the Supreme Court. We saw the hearing of the presidential election case that went to the Kenyan Supreme Court when the current president, had election and all that. We saw that the matter was decided in no time. The Kenyan Supreme Court decided the presidential election matter in about 14 days. So we want to see, as ordinary citizens like myself, we want to see the Supreme Court, with due respect, deciding this matter expeditiously. So we want to see all the parties before the Supreme Court filing all their papers and allowing the Supreme Court to decide this, because this is a public interest matter. Everybody wants to know what the position of the law is and what the interpretation of the apex court in Nigeria is about whether the president has the unfettered power to declare state of emergency in any state of the federation or in the entire states of the federation, and possibly govern alone, whether he has that power, or whether he has the power subject to some restrictions, or whether he does not have the power at all. Legal scholars, law students, practicing lawyers, political scientists, and every other person that is interested in law and governance in Nigeria is interested in seeing the outcome of this matter. What's your take about this matter that has been taken to the court by the governors of the PDP? Are they right? Are they wrong? What's your own take? Drop your take on the comment section, so that together we can also learn from you as much as possible. If you are yet to subscribe to this channel, do well to subscribe, so that together we can have a large family where we sit together informally like this. We're not in the law classroom. We're just discussing as friends. And then, as much as we can, learn the basic principles of law generally, and also the principles of law in the breaking news. Many thanks.